I see Ms. Meacham and Mr. Meacham. So let's see, Ms. Lan Kennedy Davis.
Judge Silverman. Oh, here we go. Thank you.
There we go. Ms. Kennedy Davis, we are all set. So Mr. and Ms. Meacham, are you splitting your time or is one of you arguing?
Yes, Your Honor. Let me know if you can't hear me, if my volume's not.
I can hear you.
Okay, thank you, Your Honor. What we've decided to do is that I will go 10 minutes and Ms. Meacham will be adopting my initial argument with 5 minutes reserved after the defendants go, for 5 minutes for me, 5 minutes for Ms. Meacham, if that's okay with the court.
No, because you have 5 minutes for rebuttal. So do you want to split the initial argument, 10 and 5?
And I will take 15 initially.
That will leave a total of 5 minutes for rebuttal. Are you going to argue both cases together? Is that the desire?
I think they're separate issues, and the way they were scheduled, it was separate. If that's okay with the court to do the venue.
So you can have them separately, but it's 20 minutes per side per case. So if you have 20 minutes as the appellant and you want to reserve any time for rebuttal, you and Ms. Meacham split it up any way you want, but you'll have up to 5 minutes for rebuttal. So how do you want to split the 15?
We'll reserve the 5 minutes and split that up, Your Honor.
And you're going to argue the other 15?
Yes, Your Honor.
Very good. And you want to do the same thing in the other case?
Yes.
Very good. You may proceed.
Thank you. As far as the, it may please the court. As far as the venue order, Your Honor, which is the order entered on June 22nd, 2018, Ms. Meacham and I contend that there was error because the amended complaint alleges that venue is in Hillsborough County for the reason that the statutory cause of action accrued in Hillsborough County and the action for defamation accrued in Hillsborough County and pursuant to the agreements signed by the defendant, Ms. Wynn, that placed venue in Hillsborough County. There was an original complaint that included only the statutory cause of action. Then the bar complaints, there was a finding of no probable cause on the bar complaints, and the defendants had waived any immunity related to the bar complaints, both in this case and through what was said publicly in Orlando, in the Orlando case. And because of that, there was an amended complaint that added a count for defamation. The second motion to abate and transfer, which was directed to the amended complaint, which was filed on December 29th, 2017, attached the affidavit that was directed at the original complaint. Therefore, it was directed only at the statutory cause of action. There is no affidavit directed at the action for defamation. And for that reason alone, and defendants otherwise never attempted to establish by affidavit that venue is not in Hillsborough County, for that reason alone, the court committed error. And that's, we cite to a Vitello case out of the 4th District, 123 Southern 3D 1185. And because there was no affidavit directed to the defamation count, the court was required to deny the motion to transfer or dismiss for venue. The second way the court erred as to the venue determination order is the court found that an action for a statutory action does not accrue where a plaintiff first suffers damages. Since this is a quote, it's an action for a quote, statutory real property based action. The court committed legal error. It's not a statutory real property based action. It's not a petition action. It was not a quiet title action. It just happened to be the deeds. The deeds is where the false statements were regarding the fact that the false statements does not make this a real property action. And the court actually relied on Price Waterhouse out of this court, 1999 case, 761 Southern 2nd, 1131. However, that supports that the court did err because this court held in the Price Waterhouse Cooper's case that, quote, venue principle that a tort accrues with the first compensable damage applies to all three of plaintiff's claims, including its securities fraud claim under section 517.301. So the law that a cause of action accrues normally accrues for the last element that makes the cause of action accrue. It's usually the damages. That applies to torts that are not statutory, and it also applies to statutory torts. We believe that the court erred in that regard. And again, the court found that this is a real property-based action, but it's not. We disagree. It's not a partition action, a quiet title action, or anything of that nature. Now, the court correctly ruled that venue for defamation action lies where a statement is published, but the court committed legal error in its review and interpretation of the amended complaint, which is a question of law, and found that we did not allege that a defamatory statement was published in Hillsborough County. We did allege, and that's a de novo question. The court can look at the amended complaint and see that we allege that defamatory statements were published in Hillsborough County. The court also erred in finding that Ms. Beecham and I did not suffer any damages in Hillsborough County, because the question is, at a venue hearing, we're not required to try the case, not required to prove causation, not required to prove that we actually did have damages, because a court can't basically transfer an action but rule on the merits at the same time. Or a court can't say that there's no venue but rule on the merits at the same time. And the purpose of the venue hearing was for what we alleged in a complaint, not that we're required to prove actual damages. And the court ruled that our allegations of damages in the complaint are wholly conclusory, that there's no factual basis set forth in the amended complaint, and the plaintiffs have set no cognizable theory of damages in the first place. And we've alleged the damages consistent with the forms for pleading practice in Florida. And the court was required under the law to look at the complaint, determine where we allege the cause of action accrued, not make some determination on the merits that Ms. Meacham and I did not have any damages.
Well, one question, where in the complaint did you allege that there were injuries in Hillsborough as a result of some either publication in Hillsborough or communication in Hillsborough?
Yes, I will find that specific place in the complaint when I come back on the 5 minutes. But where there's actually a general statement that all of the cause of actions accrued, and because this was an amended complaint, and we knew
so
that
paragraph 21 says, with the first damages and injuries to plaintiffs occurring in Hillsborough County. So is there any allegation as to how any damage or injury occurred in Hillsborough County?
No, other than there's just the general proximate cause that you would see in a negligence complaint. The way it's in all the forms for certain causes of action is just the general that the damages were caused. As far as this is really the only place where our damages could be, because Ms. Meacham and I reside here. This is where we practice, and there was really no way that our damages could be somewhere else that we could have first incurred damages. But it does just allege the general statement.
So there's no factual allegation as to any event taking place in Hillsborough County that caused damage?
Well, there's the factual allegations of the publications here, which would also place venue here. But
where's the allegation as to publication in Hillsborough County?
And I can come back to that, Your Honor. It's in the defamation count and in the exhibits attached thereto, which will show that publications were made to people in Hillsborough County. And I can come back and point that out.
Okay, because my recollection, I'm looking at it now, is that these statements were made in the documents that were filed in another county and to the Division of Corporations.
That's not accurate. There's actually the person that we were dealing with for the bar was located in Tampa. So there was a defamation publication in Tampa, more than one. And that's attached to the complaint. So there's the allegation, and then there's also attached as an exhibit the defamatory statements included in emails from Ms. Kennedy Davis to a person in Tampa.
So the complaint itself does not contain an allegation. You're saying it's in the attachments?
No, I believe that there's an allegation that the defamatory statements were published. I believe that it does say that defamatory statements were published in Hillsborough County.
Okay, well, if you can point that out to me, then I'd appreciate that.
Oh, okay, I'll come back. Apologize. And so I think the allegation, I will show the court that when I come back, and it's what is alleged, not that a party at a venue hearing is required to come in and prove that damages were actually caused. I think there's error in that regard, Your Honor. As far as
Mr. Meacham, okay, I can't hear. There you go. I couldn't tell if you froze or you paused.
I apologize, Your Honor. I was being quiet, which is unusual for me, but and then there was also the venue selection clause. So there was the allegations related to the statutory cause of action, the venue was in Hillsborough County, related to the defamation cause of action, which I'll show the court when we come back, those allegations. And also there was the venue selection clause, and the court committed legal error in that regard. The venue selection clause is broad. It states that any lawsuit regarding in any manner this contract or regarding in any manner attorney's representation of client must be brought in either Hillsborough County, the 13th Judicial Circuit, or the United States Middle District of Florida. And many of the defamatory statements alleged in the amended complaint are specifically directed to Ms. Meacham's representation of defendant appellee Ms. Wynn under the agreements. And because the defamatory statements were related to allegations, Ms. Meacham did this, Ms. Meacham didn't do that, then they do arise out of the agreement and are within the scope of the agreements. The court committed legal error also in regards to what the immunity issue. And I think this is an interesting issue. I couldn't find really much on it at all. I couldn't find anything supporting defendant's position. Defendant's position is that immunity, because of the bar proceeding, because there's also the immunity for statements made during a proceeding, they're separate. So there's the bar immunity and there's the immunity for statements made in a lawsuit. It's our contention that the bar immunity is lost when you take them out of that, whether you use them in a restaurant or whether you state them in another proceeding. So what we're saying is that the bar immunity was lost. They took them out of the statement. Now they were stated in a lawsuit, which if that were the only place that they were stated, that would be one thing. If we were bringing a defamation count for statements made only during a lawsuit, then the privilege related to statements made during a lawsuit, the litigation privilege would apply. But that's not what's there were statements made to these bar employees. The privilege was there, but as soon as is what was said there is taken out, and there's talk about the bar complaints, talk about things that we did and made public, whether stated in a lawsuit or not, it's lost its bar complaint privilege. That's one thing. So we believe that the court erred in that regard, and the court erred from a factual basis because the court said that responding to Ms. Meacham's allegations through motion practice and pleading is not common in public. In other words, the court found that Ms. Meacham and I had somehow made this public first, which is not the case. There's no evidence of that, Your Honor. And we believe under Tobkin versus Jarbo, 710 Southern 2nd, 975, immunity was lost when the statements were taken out of the bar proceeding and made public. And the court actually just completely ignored the statements which were provided to the court that were made in the Orlando case. So there were the statements made in this lawsuit, and there were the statements made and by the way, they don't even relate to the litigation privilege anyway. Ms. Meacham wasn't even a part of the family law case. It was just something completely unrelated to which the litigation privilege would not apply. In addition, immunity is an affirmative defense. we should have got at least to the pleading stage where the defendants would be required to raise it, because they might not even raise it. So we think the court erred in that regard. And the court erred also. So there was a disqualification order entered because our motion for disqualification was directly related to the order. The court had made findings of facts. The court had said that, well, the court's not going to consider these allegations as to the merits of the case. So no argument was made at the hearing regarding the merits of the case. Then the court believed Ms. Kennedy Davis and found that there were bar complaints pending. I believe that we were admonished, which is not the case. So we had not responded to these issues that went to the merits of the case. Those things wound up in the order. We filed a motion for disqualification. It was granted because the reasons for the disqualifications related directly to that order. We contend that order was tainted. We filed a motion for disqualification. It was granted. We filed a motion for reconsideration under Florida Rule of Judicial Administration 2.330H. The issue there is whether or not the order that we're seeking reconsideration of is tainted. And it would have to be, because the court our motion for disqualification was directed to that one hearing and to that one order. It's not a situation.
Mr. Meacham, you have about 15 seconds left if you don't want to cut into your rebuttal time.
I can conclude with that. The court instead went back and revisited the issue and found that the original judge was not prejudiced, but that was not the issue. It was whether or not it was tainted, which means we should have gotten a new hearing. Thank you.
Very good. Thank you very much. Ms. Kennedy Davis.
Good morning, Your Honors, or good afternoon by now. May it please the court. My name is Lon Kennedy Davis, and I represent the appellees and who are the defendants in this matter. For reference, in our briefs, the parties refer to the appellants as plaintiffs and the appellees as defendants. And so I will be using the terms plaintiffs and defendants for consistency today. I would like to first frame this case for you, Your Honors. This is a case of attorneys retaliating against their former clients for filing a bar grievance against them, which is prohibited. The trial court sanctioned plaintiffs for this. The August 13th, 2020 orders on sanctions encompasses the spirit of this whole case or the purpose of this whole case. It states that the plaintiffs, quote, view and have used this case as a form of retaliation against the defendants. It states that, quote, most of plaintiffs' arguments and their causes of action contain little or no merit and are either inaccurate or thinly disguised to support the campaign for vindictiveness, unquote. Plaintiffs are Mr. and Mrs. Meacham, who have appeared before you today as pro se. They sued Mrs. Meacham's former client and the attorneys who Mrs. Meacham's former client hired to file a bar grievance against them. After an evidentiary hearing, the court not only granted defendant's motion to transfer venue, but on its own accord also dismissed the case and prohibited plaintiffs from refiling in Hillsborough County. Should be pointed out, was not on the merits. They were allowed to go and file elsewhere, just not in Hillsborough County, because venue was clearly improper, Hillsborough County. But after that dismissal back in June 22nd, 2018, this case continues to be pending for you, before you, Your Honor, 5 years later from the date of filing, which is initially around April 2017. And so the trial court made specific findings in this court order awarding sanctions, that this case and plaintiff's activities were made in, quote, bad faith and was frivolous. Quote, plaintiffs have engaged in calculated course of conduct to harm, harass, bully, embarrass, and punish the defendants. And that the defendants were entitled to all their fees and costs from the beginning of the case as a result of plaintiffs', quote, bad faith, misconduct, and frivolous activities in this case. I hope that Your Honors will see that this appeal is just in furtherance of plaintiff's retaliation. Our position is simple and straightforward, Your Honor. Neither Judge Lee nor Judge Stoddard erred in their decisions, and Your Honors should affirm their decisions. The orders were supported by competent and substantial evidence, as well as Florida law. Further, before I go into reviewing the substance of the orders, Your Honors have 3 reasons I'd like to raise as to why you can deny this appeal even before getting into the substance. First, plaintiffs have failed to provide you with an adequate record on appeal. Plaintiffs did not include the transcript of the evidentiary hearing that was held on December 13, 2017, which resulted in the August 22nd, 2018 order of, June 22nd, 2018 order, of which they are appealing. They have made representations of purported facts to you, but they have not provided you with the transcript so you can review the accuracy of their statements or even what the testimony was. The order was on defendant's motion to transfer venue, wherein the trial court must make factual findings to determine venue. Case law supports that your honors may summarily deny this appeal or affirm the trial court's decision because plaintiffs failed to provide you with the complete record, a very material hearing transcript that resulted in the order of which they are appealing. Second, Your Honor, we respectfully submit that this court does not have jurisdiction to review the June 22nd, 2018 order granting defendant's motion to transfer venue because the appeal was untimely. Plaintiffs went and filed a motion for rehearing, and that motion for rehearing was denied on June 1st, 2020, which set the deadline for them to appeal to be July 1st, 2020. They did not appeal until well after that. Third, this court also does not have jurisdiction to review the June 1st, 2020 order because the appeal was untimely. The deadline to appeal that was also July 1st, 2020, which deadlines they have also missed. Next, I would like to review the trial court's order and to show that they are supported by substantial competent evidence and they should be affirmed. Plaintiffs filed two separate appeals. I think for now, we're just talking about the first appeal. They appealed the first three orders. That is the June 22nd, 2018 order, June 1st, 2020 order, and the July 31st, 2020 order. Those three were noticed on appeal. For start, I would say that they made no arguments whatsoever on the June 31st, 2020 order. And as is shown in their initial, and that should be, they have waived their rights and abandoned their arguments in the July 30th, 2020 order. With regard to the June 22nd, 2018 order granting our motion to transfer venue, Judge Lee made the following findings properly. That section 47.011 Florida statutes governs where actions may be brought. It was undisputed that no defendants reside in Hillsborough County. She found that it was undisputed that no defendants regularly conduct business in Hillsborough County. She found it was undisputed that none of the deeds at issue were recorded in Hillsborough County. Judge Lee stated that plaintiffs provided no basis to support their claim that venue lies where they reside. Judge Lee stated, and I quote, Mrs. Meacham provided no authority for this unique proposition that venue lies where plaintiff resides and is based upon, quote, her travel patterns. She dismissed that claim and that argument. With regard to plaintiff's claim that venue lies where they suffered damages as a result of defendant Wynn's recording of the deeds, Judge Lee found that one, it was undisputed that plaintiffs do not now, nor have they ever had any ownership interest in the real properties that were related to those deeds. She found that plaintiffs did not allege any factual basis for the claim that they were adversely affected or damaged by the filing of the deeds as required under section 817.535. She found that they did not identify in any damages that they have suffered, never mind that they had suffered damages in Hillsborough County. With regard to plaintiff's claim that Mrs. Meacham's retainer agreement, specifically the forum selection agreement that they tried to bootstrap this case to, that governs this dispute, the court also rejected this argument. Judge Lee said that plaintiffs have provided no basis to support their claim that Mrs. Meacham's former retainer agreement with defendant Wynn, a former client, governs this dispute, which the plaintiffs assert arises out of defendant Wynn's new attorney's representation. She said that there could be no legal theory that could be advanced that defendant Wynn's new lawyers would be subject to Mrs. Meacham's engagement letters. She said that there could be no legal theory that that another law firm would be subject to Mrs. Meacham's engagement letters. And it's important also, Your Honor, that Judge Lee addressed plaintiff's credibility at the hearing. In footnote 4 of Judge Lee's order, she stated that plaintiffs defended the Florida bar grievance by claiming that there is no conflict of interest for Mr. Meacham to sue Mrs. Meacham's former client, and that they stated that they testified they do not work together or share any information about clients together. But now, in order to advance this action, they are representing, they've testified contradictory to this court, to Judge Lee, that they claim that they share in the engagement letters between Mrs. Meacham and defendant Nguyen. Both cannot be true. Judge Lee noted that in her footnote 4, and she was not going to permit them to make contradictory claims, and she held them to their sworn statements to the Florida bar. And she rejected their argument. Regarding plaintiff's claim that they suffered damages in Hillsborough County due to statements made in the Florida bar grievance, Judge Lee also found no support for this. She said that, quote, "It is clear from the testimony that at the hearing, which transcript they did not provide to you, that the grievance process spawned from the family court dispute which was in Orange County, and was not from the original matters for which Mrs. Meacham was retained." And those were concerning leases, I believe. Judge Lee also found that it was undisputed, I quote, "that both the office of the Florida bar, to which the original bar complaints were made, and the Florida Division of Corporations are located in Tallahassee, not Hillsborough County. That plaintiffs made no allegations that defendants made any public statement, announcement of the contents of the bar grievance anywhere, never mind in Hillsborough County, and that defendants are provided with absolute immunity under the Chopin v. Jarbo case. Therefore, Judge Lee conclusively found that plaintiffs did not establish that venue is proper in Hillsborough County. And not only did she grant our motion to transfer venue, she decided to dismiss the case and prohibited plaintiffs from refiling in Hillsborough County. She only reserved jurisdiction to determine any, not just any award for fees, she said, including under section 57-105. Judge Lee's order was based on competent and substantial evidence and was made after an evidentiary hearing, which transcript plaintiffs is not provided to you. But not providing you with that transcript, they cannot request that you find that Judge Lee committed error in findings of fact, and solely on their word. The second order, Your Honor, that was appealed was the June 1st order. The June 1st, 2020 order denied two motions. First, it was a motion for reconsideration under Rule 2.330, and second, it was a motion for rehearing under Rule 1.530. I'll take each one of them up separately. Rule 2.330 states that any successor judge may, not shall, vacate the prior judge's order after disqualification. Judge Stoddard correctly denied their motion as they failed to comply with the requirements in the Rath case. Both parties relied and agreed that the Rath case controls. Judge Stoddard stated in his order that plaintiffs were required to point to the record specifying all the errors that they claimed that Judge Lee had committed in her order. Instead, Judge Stoddard stated that they merely filed a bare bones motion and they attached records, about 300 pages of it, and all of it was just prior records that were already in the court file. The order states that the quote, "the motion does not detail the reasons."
Kennedy Davis, you've read a lot from the orders. We know what the orders have said. We're thoroughly familiar with the record. Is there any legal argument you want to make?
I don't think so. I mean, like I said, it is straightforward. The only legal argument is that I believe that they contend that it was that it was shall, that Rule 2.330 says shall, but it is may, and that they are required to point to the record. They failed to point to any of the record. And also that it was important, they sought to vacate that, Your Honor, their order. And it's important that Mrs. Meacham also did not appear for that order, for that hearing. So therefore, It is our position that the order was accurate as to the motion, as to denial of their motion for rehearing. It was within the court's discretion. The rule says may and not shall. They failed to comply with the RAF requirements in the RAF case. And Mrs. Meacham did not even attend the hearing. And I'll address that afterwards. And the court said that she intentionally did not attend the hearing, that she refused to attend the hearing, that she, and I quote, the court, she misrepresented to the court that she could not attend the hearing because she had a jury trial in Lee County in May 2020, when all jury trials had been canceled statewide due to COVID. So she didn't even attend the hearing. So it's our position then that Judge Stoddard's order was accurate, legally sufficient. It was also based upon competent, substantial evidence. They failed to meet their burden under RAF, and Mrs. Meacham didn't even appear for the hearing.
Very good. Thank you, Ms. Kennedy Davis.
There's another, is there more?
You have 2 minutes left, but I thought you were concluding there.
Okay.
Again, I'm just going to tell both parties, you do not need to go back through the record on appeal. We understand what's in the record, so please go ahead and limit yourself to any legal argument and facts related specifically to that legal argument.
Okay, then with regard to the motion for rehearing in the June 1st order, Your Honor, plaintiffs claimed that the court, Judge Stoddard, should not have ruled on it because it was not noticed for the hearing on the same day as motion for reconsideration. They denied that there was an agreement on the record. However, the record, and I point you, Your Honor, to the record, pages 2105 to 2107 of the record, that plaintiffs expressly agreed that the court shall rule the same for both motion for rehearing and the motion for reconsideration. So not only did they expressly agree, but they did not object and preserve that issue for rehearing. And then lastly, Your Honor, like I said, in the July 31st order, they did not even make any argument on that. So it'd be our position that they have waived any right to make arguments and that they've abandoned that. And I just want to quickly address, they said that we did not file any affidavits. Your Honor, I'd like to point you to the record on pages 50 to 57. All defendants filed their affidavits in the court file. And lastly, they raised the Price Waterhouse argument in the June 22nd order. And Your Honor, I'd like to point out that in the court order on footnote 2, the court said that she did not take that into consideration because that it was a different case. It was concerning securities fraud. It was not about the statutory real property and deeds issue. That's all I have, Your Honor. Thank you.
Thank you very much. Mr. Meacham, you have your 2.5 minutes.
Thank you.